Washington Journal continues.
We're back with Danielle Holly Walker and Josh Blackman, two law professors who are here to help us understand this draft opinion and what the entire issue is around the constitutional issues on Roe v. Wade and this decision. Danielle, Josh, good morning.
Good morning.
All right, Danielle, I'll start with you. Remind us what was at issue in the Dobbs v. Jackson Women's Health case and the upshot of this draft opinion.
Yeah, so what we're really looking at in the Dobbs case is a Mississippi abortion ban of 15 weeks. It does not have exceptions for rape or incest. It is, under the current law, under Roe and Casey, almost very clearly unconstitutional under the current precedent. So that's why in the draft opinion, you see Justice Alito write that Roe and Casey are explicitly overturned. So Roe versus Wade was decided almost 50 years ago. Casey was decided 30 years ago, and both hold that there are limitations on how the government can regulate women's health in terms of abortion. So what the draft opinion really does is it says that abortion rights are not protected under the Constitution. So therefore, states do not have to justify regulating a woman's right to get an abortion. So states like Mississippi, Texas, Louisiana, other states that are seeking to regulate abortion would not have to basically justify why they're doing that under the Constitution.
Now, Josh, can you explain to us what Justice Alito's legal justifications were in his draft opinion that would overturn Roe v. Wade?
There are two primary aspects of Justice Alito's leaked draft opinion, which, to be clear, may not be final, but the version that we have has two major parts. The first part is based in text and history, and Alito explains that under the Constitution, as was understood in 1868, there was no notion of a right to abortion. Many states, not all states, but many states banned abortion at various points in time. Some banned it earlier, some banned it later, but there was no discussion that this was a right, let alone a fundamental right. And so therefore, because there's no deeply rooted history of this right to abortion, the Constitution doesn't protect it. The second part of his opinion turns to what's called stare decisis, this notion of precedent, the court stand by precedent. And here Alito says that Roe v. Wade and another case called Planned Parenthood versus Casey, these two decisions were egregiously wrong and have not settled controversy, have remained contested, have been difficult to apply, and all the criteria which you consider keeping a precedent support getting rid of this precedent. So in light of these two factors, the court overrules Roe v. Wade. As Danielle mentioned a moment ago, the issue of abortion returns to the states. California can allow abortion to the moment of birth, and Texas could ban it from the moment of conception under the Alito opinion. There's a wide range of what states can do.
So I'll throw this one out for both of you. We've heard a lot of talk about stare decisis. In fact, one of our callers just in the earlier segment said, hey, well, Plessy v. Ferguson, that was a decision that was overturned by the Supreme Court. How often does the Supreme Court go back and say, hey, this earlier decision was wrong? Was this something unusual if it happens, Danielle?
Yes, it is. I think Justice Alito in the draft opinion tries to establish that obviously precedent has been overturned before. The biggest example that people give is the one that your caller gave, that Plessy versus Ferguson, which allowed for racial discrimination in the United States by the states under Jim Crow, allowed that for almost 100 years, and Brown versus Board of Education overturned it. However, that's why we call it precedent, right? That's why we call it stare decisis, this notion that the Supreme Court is supposed to, and the lower courts are supposed to follow the Supreme Court. Supreme Court follows its own precedent. And they do that for a number of reasons, including to make sure that people understand what their rights are. So it is a very serious undertaking when the Supreme Court takes a right that's been established by the Supreme Court itself for almost half a century, like abortion rights in Roe, and then extinguishes those those rights. So the difference is that in Plessy, they limited the rights of Black Americans and then they expanded those rights. I think the difference is here that the Supreme Court said you do have a right to privacy, which leads to a right to decide your medical care with your doctor. Because remember, when we talk about abortion rights, this is really about women being able to have a private conversation and decision with their doctor about whether to have abortion. After understanding that we have that right for 50 years, now the Supreme Court is trying to extinguish a right. So they're not giving more rights, but they're taking a right away. And I think that is a very particular way of thinking about precedent and why so many people are disturbed by what the draft opinion said.
What do you think, Josh?
Well, I think there's two types of rights here. There's a right to the individual and the rights to the people that govern themselves. Justice Scalia made this point many times that the most basic right we have is the right to govern ourselves. We fought for independence for that reason. So in a way, it extinguishes perhaps one right of the people to have a right to abortion, but also restores the right of people to govern themselves and to choose what laws to adopt. But the court has reversed precedents that have taken away rights. Perhaps most famous is not very popular, but involves a right of contract. During the early 20th century, the courts understood the 14th Amendment to protect a right of people to contract, which means that certain economic regulations were unconstitutional. That was the law of the land for about 4 or 5 decades. During the New Deal, the court said, no, you don't have this right. We're taking it away. But I agree with Danielle. It is rare for the court to overrule a 50-year-old precedent. You can probably count on maybe two hands the number of times it's been done in this regard. Justice Alito has this very long footnote of many decisions that have overruled precedents, but I don't think any quite rises to the level of Roe, except for maybe Brown and maybe one or two others.
Let me remind our viewers that they can take part in this conversation. We're going to open up special lines. If you support the Roe v. Wade decision, we want to hear from you at 202-748-8000. If you oppose the Roe v. Wade decision and think the Supreme Court is right in possibly overturning it, your number is 202-748-8001. Keep in mind, you can always text us at 202-748-8003, and we're always reading on social media, on Twitter at C-SPAN WJ, and on Facebook at facebook.com/C-SPAN. Now, Josh, I'll start this one with you. Can you explain to our viewers what Planned Parenthood v. Casey is all about and what's its role in this decision?
Sure. So there are two decisions for abortion in the Supreme Court. The first was Roe v. Wade in 1973. This case explained that the government's interest in regulating abortion changes as the 9 months progressed. So in the first trimester, that is the first 3 months, there are very few regulations on abortion that are permissible. In the second trimester, the next 3 months, there's increasingly more regulations that are permissible. And of course, in the final trimester, there are pretty broad ability of the state to prohibit abortion altogether. That was a rule for about 20 years. Then we get to 1992 with Casey. And Casey was sort of a weird decision. There was no single majority opinion, right? There was no opinion that garnered 5 votes. But there was a controlling opinion that garnered 3 votes. So it was by Justices O'Connor, Kennedy, and Souter. And they said, well, we're going to keep this right of abortion, but we're getting rid of the trimester framework. We're not going to use trimesters anymore. Instead, we'll draw the line at the point of viability. Prior to the point of viability, the state cannot impose substantial burdens or obstacles on the right to abortion. Now, usually when I say this, people ask, well, Josh, what's viability, right? What's that line? Of course, that varies based on science, whatever neonatal technology is. Maybe if you're in a big city and you have access to a large hospital, viability is here. And maybe if you're in a very poor rural area, viability is there. The court didn't purport to draw any bright line of when viability is. In fact, it changes, I guess, from year to year. The Alito opinion overrules Roe and Casey altogether. It says that this right to abortion doesn't exist, so we don't need to draw the line, that the states can now draw the line of when abortion is permissible and when they are not permissible.
Now, Danielle, is Justice Alito making a choice to overrule both Roe and Casey, or if one falls, the other one should fall as well, or is he making a choice at going after both of them at the same time?
In the draft opinion, it explicitly says that the court is overruling Roe and Casey. I think the only thing I would add to what Josh said is just that Casey, of course, was the three opinions that kind of saved Roe. In Casey were by Republican appointed justices, because I think even at the time of Casey, those justices recognized that the right to privacy, which again gives rise to the right to abortion, is something that at that point was so established that they did not want to overturn it. So this has not been the first time that the Supreme Court has been asked to overturn Roe, and they made a very different decision in Casey. So while it absolutely shifted the trimester kind of philosophy of Roe and went to viability, they still kept the basic idea that there is a right to privacy in the Constitution that gives rise to the right to abortion.
And I guess I should have asked this question earlier, but I'll ask it now. How confident are the two of you, Josh and Danielle, that this leaked opinion is where the court stands right now?
That's my shrugging emoji. I have no idea. Right? If you read the Politico story carefully, the Politico story cites some unnamed source that says, as of last week, the 5 members of the majority were holding. Right? That was last week. We know things don't stay. I wrote a book on the Obamacare litigation from 2012. We know the Chief Justice changed his vote, or at least we're pretty sure he changed his vote. So lots of things can happen. I don't know. We have, if anyone says they know that, they're lying. No one knows, unless you're Brett Kavanaugh or Amy Coney Barrett, but no one actually knows.
Do you agree, Danielle?
Yeah, I think that all we know based on the Chief Justice's statement, official statement, is that this was an authentic draft. We know that there is, Linda Greenhouse and others have reported, there's a lot of cutting and pasting in this draft that comes directly from briefs that were filed before the court. So it's unclear how far along this draft was. So that's the only thing I would caution people is, for all we know, this was the very first draft that was circulated after the justices conference. They make an initial vote. The case opinion is assigned to someone, in this case, Justice Alito. He wrote a draft. We have no idea whether this is the very first draft or if this is the most recent draft the day before it was leaked to Politico. So that's the caution I would give, is this may be a draft that has now been rewritten 5, 6, 7, 8 times. I strongly agree that we should not attempt to say that how far along they are in the writing of this draft.
Okay, I'm glad we got that question out before I go start reading passages from the draft opinion. So now we all know where we stand. But I want to point this passage out and then ask a question. Here's a paragraph from the draft opinion that would overturn Roe v. Wade. It reads, "We hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in the nation's history and tradition, and implicit in the concept of ordered liberty." Now, Josh, what is the Due Process Clause of the Constitution, and what does it have to do with this case?
So the 14th Amendment was ratified in 1868 following the Civil War. And there are a couple of big provisions of the 14th Amendment. First, it guarantees equal citizenship for all people born in the United States. If you're born here, you're a citizen. I might get some callers on that one. It also protects what's called the right of equal protection. This was the basis of the Brown versus Board ruling, that generally the government can't treat you differently based on your race and other factors. Then there's this other provision called the Due Process Clause. And the Due Process Clause says the government cannot deprive you of life, liberty, or property without due process of law. The Roe decision looked at this word liberty in the Due Process Clause and said, well, what is liberty? Is there some liberty that's so important that it can't be taken away from you, that no amount of procedure can justify the deprivation of this liberty? And the Roe court wasn't really sure whether the Due Process Clause protects it. Maybe it was something else, maybe another amendment, but whatever. There was this right of privacy. It was very sort of vague about the basis of this right. What Alito's saying is that the court's tests, the court's framework to decide what liberty is. Under this framework, you don't get to abortion. There's no right of abortion under this framework. And therefore, the Roe decision was simply wrong to say the Due Process Clause protects abortion as liberty.
Danielle, was this the correct application of the Due Process Clause of the 14th Amendment?
What I'll say is that it goes strongly against longstanding Supreme Court precedent. So I think what we're seeing is that this is not the only right that is not, I think, especially two parts that you just read. Number one, I think the idea that it's not explicitly found in the text of the Constitution. There are lots of rights that are recognized under our law and that have been recognized by the Supreme Court that are not explicitly in the text of the Constitution. So, for example, a right to marry is not explicitly in the Constitution. So under Alito's theory, arguably a state could say no one in our state can marry. And if someone challenged that, he would simply say, all right, the right to marry is not found anywhere in the Constitution. And he would probably save it through the second part, which is it deeply rooted in American history? He would say marriage is, but there are lots of marriages that were not recognized in 1868, including men and women of different races marrying, including, of course, same-sex marriage. So I think that's what people are really focusing on, is this notion that if we begin to overturn Supreme Court precedent on the basis that the right is not explicitly in the Constitution and that it was not deeply rooted in American history, meaning at the point that it was adopted into the Constitution, so in this case, 1868 for the 14th Amendment, that would collapse a lot of what the rights that are currently recognized by Supreme Court precedent, including things like Obergefell for same-sex marriage, Loving versus Virginia for interracial marriage. And that's why that portion of the opinion is so deeply troubling to many people.
Josh, do you agree with Alito's reasoning that since abortion isn't deeply rooted in the nation's history, it's not a protected right?
Well, we have two different strands of case law, right, on the Supreme Court. We have some cases from Justice Kennedy, who said, well, history is important, but it's not the end-all be-all. And he used reasoning in a case involving gay marriage, the Obergefell decision, in a right to sodomy, Lawrence v. Texas, and a few other cases. And then you have the second strand of the Supreme Court's cases, which say, no, we need to have rights that are clearly defined in American history. For example, Washington versus Glucksberg, where the court said there's no right to have an assisted suicide. So you have these two strands of case law that have always just sort of lived in parallel, that were never clearly reconciled. Now that Justice Kennedy's gone, the court's saying, okay, that's nice. We're going to go back to the Washington v. Glucksberg test, the deeply rooted test. And Alito goes out of his way to say, we're not discussing gay marriage here. We're not discussing interracial marriage. We're not discussing anything else. This is all about abortion. And I'm sure a lot of people don't believe him. But I think the bigger issue is that there's no national movement to bring back interracial marriage bans, right? There's no national movement to ban birth control. There's really no national movement to get rid of gay marriage. It's a decision that's taken root quickly. In only 7 or 8 years, the decision came out. Yet abortion, I think, stands alone. That every year there's marches in Washington for half a century. It's a sort of this unique singular issue that's sustained, where other issues just sort of fade to the background. I mean, interracial marriage is like a 90-something% support rate. So sure, I mean, if we skate down the slope of the decision, could we reach a place where interracial marriages are banned and contraception bans brought back? I suppose, but I think it's very unlikely. But as a constitutional matter, the lead opinion does undermine the basis of these other landmark decisions.
Let's get some of our viewers into this conversation. Let's start with Liz, who's calling from Jonesboro, Georgia. Liz, good morning.
Good morning. Good morning, Jesse, and good morning to all your guests. I'm learning a lot. I really appreciate their knowledge. But my question is, just as this case came before the Supreme Court based on this Mississippi law, can this come back again? And I'm thinking Alito has talked about the decisions being egregious. Is it not going to be egregious when people start being charged with homicide, because one state has already kind of decided that, or they're moving in that direction, that you can go to jail. You know, you can be convicted of murder. What's going to happen when people start shooting people in your state, perhaps in Texas, because they have the right now to be vigilantes? So can this case come back in some other form before the court again?
I'll let you jump in first, Josh, since you mentioned Texas.
Oh, shoot. Thank you, caller. Well, I think there are two separate issues, right? One is, could the court revisit Dobbs? In other words, let's say in a couple of years, the Democrats expand the Supreme Court, add 15 new justices. I mean, somewhat facetious. Could the Supreme Court reverse Dobbs and direct Roe? Of course, right? I mean, the Supreme Court can go back and forth like a ping pong. I think that's unlikely. The next part of your question concerned whether states will now treat abortion as a felony, and in fact prosecute pregnant women who seek to obtain an abortion. Historically, even before Roe, and I don't want to speak with absolute certainty, but most of the rules were imposed against the doctors. I think it was rare. I'm sure it happened, but it was rarer that the pregnant woman was actually charged with a crime. I think that's the general consensus today among pro-life communities. I can't speak with absolute certainty, but the general consensus is you punish those who facilitate and provide the abortions, and not the pregnant woman. I think that's generally how it's done, but of course things can always change. One other thing to keep in mind, I realize that today there's this free-for-all where states are enacting all these very restrictive measures. There's no guarantee these are sustainable. Politics do shift, and I think people may realize that they might have overreacted. Maybe not right away, but at some point there might be some sort of retreat. And I think that would reflect the fact that the political process can be restored. As it stands now, the Supreme Court has basically taken over this issue for half a century and it's told the states, we're going to tell you what you're allowed to do. And when this issue goes back to the political process, I think there'll be more give and take than there is today. I don't think it will be as absolute as things seem now, but maybe I'm wrong. What do I know?
Danielle, what do you think?
I think that the caller is exactly right. I think what we've seen is that when this goes back to the states, there will be many states that don't enact lots of restrictive laws on abortion. But I think what we will see is some very extreme laws that will be adopted on abortion. I think the one that the caller was referring to was the Louisiana law that has been proposed and came out of committee this week that would criminalize women and charge them with murder for getting an abortion. I think we've also seen the Texas abortion law that, of course, creates kind of a bounty hunter situation where people can report women, private citizens can report women for having abortions. So I disagree that there won't be a strong turn in favor in some states. And I think that's the other, troubling part of this is the idea that women's rights will be different in California than they are in Louisiana or Mississippi or Texas. But I think we can expect, just like in Shelby versus Holder, when the Supreme Court predicted that voting rights, we were told by Chief Justice Roberts that essentially the southern states were no longer interested in really enacting these restrictive voting rights that would impact people on the basis of race. In less than a week after Shelby was decided, we saw many states that began to enact very restrictive voting laws. And I think that's exactly what we'll see in the aftermath of Dobbs. If this turns out to be the decision, is there will be many states around the country who will enact draconian laws that prevent women from getting healthy and safe abortions and will hurt women's health tremendously.
Now, Danielle, you're not only a law professor, you're dean of the law school at Howard University.
Yes.
Does this leaked opinion change in any way how we teach law or how we think about law?
Oh, absolutely. I think that the Supreme Court, if the draft opinion, especially the portion that you read, I'm so glad you read that portion, that's the most troubling part of the opinion in the sense that it essentially overturns a half century of precedent in one sentence. Roe and Casey are overruled. They were egregiously wrongly decided. To do that, I think, opens the door to overturning lots of precedent in stare decisis. So that is why many across the political spectrum were troubled by the draft opinion, because one thing the Supreme Court is supposed to do is create predictability in our law. They establish a right, and then it's not overturned. They establish what people's rights are, and then we can rely on them. And so if this is overturned, for example, they have an affirmative action case, 2 affirmative action cases that are being heard. Those rights have been long established, that there is the ability of universities to use race in a limited way when admitting students to higher ed. I expect them to maybe overturn those precedents too, things like Bakke and Fisher and Grutter. So once you open the door to a Supreme Court that is activist in the way that this draft opinion demonstrates activism, judicial activism, what we may see is the overturning of other precedents, longstanding precedents, and that will be troubling, I think, to many Americans.
And Josh, same question to you. You're a professor at the South Texas College of Law, Houston, and you're also the founder and president of the Harlan Institute. Does this, if true, this draft opinion is true, does this change how we teach law and how we look at the Supreme Court?
I think of the Supreme Court in the sort of historical perspective. It cycles. There have been some conservative courts, some liberal courts, and now we have a conservative court. Many decisions that we have were established by the Warren Court in the 1960s and 70s. And those were decisions that, in large part, changed things. When Roe was decided, I think 40-something states banned abortion altogether. And that was a radical shift in how law existed. There were many decisions in the criminal procedure context, in the voting rights context, where basically stuff was, frankly, made up. A movement was born for the course of 40 years saying that these decisions were wrong. So I don't see this as entirely surprising. I think this is a consequence of Republicans appointing more judges to the Supreme Court than the Democrats have. Even in the past, people like Sandra Day O'Connor, David Souter, and Anthony Kennedy were Republican appointees who upheld these precedents. So I think I largely agree with Danielle. The current court is seeking to correct long-standing decisions they think were wrong, which those decisions themselves changed long-standing precedent of how people view the world. Will it change how I teach the course? It's not significantly. It's just another lesson at the end. We can start at the beginning, the early 20th century, go to the middle, then go to the end, then go to the 21st century. I think constitutional law is a class that's sort of always changing. Every year there's different precedents you have to learn. What I do think this affects, and actually I'm actually far more worried about the leak than the decision itself, maybe I'm the only one here, is how this will affect the court's ability to do their job in the future. That if now draft opinions can be leaked out and people can start pressuring justices based on what this is, really a rough draft, I think it becomes harder for the court to do their job. If other decisions start leaking out, the court becomes compromised. And I'm actually far more concerned about the ability of the court to decide their cases and how they decide this particular case.
How important is the leak, Danielle, before I get to our next caller?
What I would say is I think the real challenge to the Supreme Court's institutional ability to do its work is the substance of the draft opinion itself and not really the leak. While I agree that I clerked on a federal appellate court, I do think that the ability of judges to do their work in a way that's private in their process so that we don't have to speculate about things like draft opinions, I do think that that's an important principle. But I think more important than that is we currently have a number of justices on the court who during their confirmation hearings said that they had respect for precedent, and especially what are known as kind of the super precedents that have been around for a long time and that are relied upon by the American people, like Roe. We had a number of justices who said that they understood what Roe meant and that they respected precedent, and they're now explicitly going against that only several years after their confirmation hearings. And I think that is what really erodes confidence in the Supreme Court. And I think also what we've seen in terms of the nomination process, the way that Merrick Garland was not given a hearing, but Amy Coney Barrett was given a hearing along the same timing. Those are the things that are eroding public confidence in the Supreme Court and have made the court now seem like another branch of political institution more so than what we expect from the court. And again, the history of the Supreme Court, I agree strongly with Josh, goes back and forth. And over time, people have respect for the court. When it's a conservative court, liberals are outraged. When liberals are on the court, conservatives are outraged. So that's normal. I think what we're seeing that's not normal is this idea that we have such politicization of the appointments process, and then people who in their confirmation hearings say one thing and are now doing another.
Let's go back to our phone lines and let's talk to Linda, who's calling from Spring Hill, Florida. Linda, good morning.
Good morning. Good morning. Just please have a little patience with me. I'm only making comments. First of all, I believe in abortion when it's needed up to a certain point, because after a certain point, that baby is alive. I believe it's alive at first time, but if you need an abortion, you have to stop it at a certain time. You know, you can't rip off the arms and the legs and all that stuff after that. That's murder, okay? And second of all, I also believe that what's going on now and showing themselves with all this picketing and stuff is horrendous, because they're showing it's my life, and I do what I want. Then don't get pregnant. I know sometimes it happens. I also believe in rape and, young kids have an abortion. But these people are not thinking about the life they're carrying inside their body. So they're showing a total disgust to a lot of people of a church that's a religious belief, and that's it. And they shouldn't be doing that. And I've seen them even blow up clinics of abortion and stuff that believe in life. They're very wrong. There just has to be certain restrictions that I do believe in, but there has to be a certain amount of time when you can't have an abortion. Go through it, give it up, and turn it and have it for adoption purposes. But this is way out of hand and ridiculous, and I'm kind of tired about hearing about it's a black issue. It is not a black issue. It's everybody's issue. I'm so tired of hearing that, and everybody else's. This is everybody's issue, and I thank you for listening to me.
Josh, Danielle, who wants to jump in on that comment first?
Well, one thing I'll say to the caller, number one, we just heard the caller essentially parrot what is the law, right? So what she talked about in terms of, making sure that abortion is regulated after viability, or in the Roe system after the first trimester, that's essentially the law. So the caller actually supports what is the current Supreme Court precedent for Roe and Casey. I think second, we have to remember that Roe and Casey don't really say, tell women how to regulate their bodies. Should they use contraception? Should they get an abortion after a certain amount of time? I think the important thing is that when we think about women having children, this is the most private and sacred decision a woman can make. So Roe and Casey don't attempt to say, women, please go out and have abortions. What they say is that the government, the same as many people didn't want the government to tell them to wear masks or get vaccinated, here we're asking, can a state government like Louisiana or Texas or Mississippi direct a woman when she is allowed to get a medical procedure, such as an abortion? And we also have to remember that many women get abortions not because they want to, but because their health really dictates it. And when we think about laws like the one in Dobbs, this doesn't have an exception for incest or rape. So if a woman's raped and she wants to get an abortion early in her pregnancy, what the Mississippi law does is take that ability away from her. So this isn't about individual women's choices in the sense of what's best for them, but can a state government tell a woman, direct a woman, how her health needs to be addressed when she's pregnant? So that's what I would say. And finally, the racial comments. I think it's very important to realize that, of course, the right to abortion, right to privacy affects all of us. But there can be outsized effects on some groups, because what will happen is if abortion is outlawed in many states, women who have wealth, women who have opportunity to go across state lines will do that. Women who are poor or women who do not have that access will be the ones who will actually be denied the ability to control their own health. So that's why people bring up things like race and class when we talk about abortion. So it's absolutely not just about one group of women, but we do have to pay attention to the questions of how certain groups of women may be more impacted by this decision if the draft does become the final decision.
Josh, I want you to tackle the part that Danielle said there that we heard earlier over the last 2 years or so, the whole my body, my choice when it comes to vaccines. Is there any link between the government being able to mandate vaccines and the governments, state or federal, being able to regulate abortion?
Yeah, I think the issues are somewhat related. There's a long-standing line of precedent saying the government can't put stuff into your body. They can't conduct experiments upon you, perhaps, right? They can't randomly, forcibly constrain you unless they have adequate justification. Then again, under Supreme Court precedent, the government can forcibly sterilize you. A case called Buck v. Bell from 1925, give or take a few years. So it's not a very clean line of precedent. So at least in the modern era, people say, don't put the jab, right? Don't put the needle in my arm. But in the same breath, some states are saying we will prevent you from having an abortion, and we're going to keep the child in a woman's body until birth. I did want to address the point of viability. Under modern science, it's somewhere in the 20s, 23, 24, 25, 26 weeks, depending who you ask with different answers. So we're talking about 5 or 6 months, maybe 4 months, but usually 5 or 6 months is viability. Mississippi banned abortion at 15 weeks, which is just short of 4 months. Under Roe and Casey, Mississippi can't draw that line at 4 months because it's before the point of viability. I'm not sure what point the caller was asking before, but 14 weeks is before. 15 weeks is prior to that point. I've seen studies showing that 90% of abortions are before the 15-week mark. So the overwhelming majority of abortions would actually fall well before the viability point. But I still think if the Alito opinion holds, it could be 15 weeks, it could be 6 weeks, it could be, 0 weeks is a possibility, but it could be really at any point.
I want to play for you from the December 1st argument, that very topic where Justice Alito is questioning Julie Reichelman of the Center for Reproductive Rights about the issue of fetal viability in the debate over abortion access. Here's that exchange.
If a woman wants to be free of the burdens of pregnancy, that interest does not disappear the moment the viability line is crossed. Isn't that right?
No, Your Honor, and if I may make a few points to answer your question. First, I think the state views viability as arbitrary because it completely discounts the woman's interest. But viability...
No, but does a woman upon reaching the point of viability, does not the woman have the same interest that she had before viability in being free of this pregnancy that she no longer wants to continue?
Viability is a principled line, Your Honor, because in ordering the
I'm
interest...
trying to see whether it is a principled line.
Yes,
you agree with me at least on that point, that a woman still has the same interest in terminating her pregnancy after the viability line has been crossed?
Yes, Your Honor, but the court balanced the interest, and in ordering the interest at stake...
Look at the interest on the other side. The fetus has an interest in having a life, and that doesn't change, does it, from the point before viability to the point after viability?
In some people's view, it doesn't, Your Honor, but what the court said is that those philosophical differences couldn't be resolved in a way...
That's what I'm getting at. What is the philosophical argument, the secular philosophical argument for saying this is the appropriate line? There are those who say that the rights of personhood should be considered to have taken hold at a point when the fetus acquires certain independent characteristics. But viability is dependent on medical technology and medical practice. It has changed. It may continue to change.
Josh, jump in here and tell us a little bit about what we heard there. And then Danielle, I want you to address that conversation there too.
Sure. The viability point never made a whole lot of sense. It might make sense as more flexible than the trimester framework. But what Alito's getting is, why does a woman's interest in terminating the pregnancy change whether the child is viable or not, right? What difference does this actually make? At bottom, we're having more or less a philosophical discussion about when the state's interest is sufficient to override the mother's interest, and viability is not a particularly useful line. There is no good line, right? I mean, if you're a court and you're making something up, the trimester framework at least had the advantage of clarity. You knew when 3 months were up, you knew when 6 months were up. But the viability line will fluctuate based on science. It might be based on where you live. It might be based on such variable situations. So maybe for some, it's 23 weeks, others 26 weeks. And it's not really clear that courts are in the business of making these sort of difficult line drawing problems. In fact, Alito says one of the reasons why he's overruling Roe is the viability line is proven unworkable. And the lower courts have kind of gone every which way to decide which is which and how to use the standard.
Danielle?
A couple of things. I think first, you hear Justice Alito using the language of the pro-life movement very strongly in that clip, particularly this idea that of fetal viability. And I think the idea is that many believe that the pro-life movement is moving in the direction of trying to determine or state that viability happens at the very moment of conception, and which is, of course, a religious view and is one that we saw enshrined in, for example, the Louisiana proposed law this week, which would essentially mean that states could, if we still kept the viability structure, outlaw abortion at the moment of conception. And we know that there are lots of things that could be impacted by that, like IVF treatment, IUD treatment. So I think anyone who thinks that this is the end, kind of just overturning Roe and Casey, I think what we could see in states is the adoption of fetal viability laws. I think the other thing to pay attention to is, of course, that viability, just like many of the standards that are employed by the Supreme Court, it is not an easy standard to apply, right? So these are difficult tests to apply. Viability is a difficult test to apply because of technology, et cetera. But just because a rule may not be clean cut or, quote, workable, according to the draft, I'm not sure why that leads to the overturning of Roe and Casey. Maybe it leads to the overturning of Casey and going back to the trimester system under Roe. But the notion that the test is hard to apply, to me, doesn't justify saying we're now extinguishing a right to abortion completely and leaving it to the states to decide.
Let's go back to our phone lines and let's talk to Diomia, who is calling from New York. Diomia, good morning.
Good morning. Actually, some of the one of the questions that I had has been discussed briefly regarding the last 3 Supreme Court people that was put on. I think in their questioning, they had agreed that they would not touch long-standing laws, and so that part. But then I had a statement to make is for people who claim to be religious and whatnot, and want to follow the commandments, one of the first ones is "Thou should not kill." And why do we go in other countries and try to tell them what to do and kill them with drones and kill innocent babies and children over there? And we preach not killing babies here. The commandments say do not kill. And when it says do not kill, that means do not kill anyone. If someone has done something wrong, we should punish them, but not kill them. And we at times want to execute people. If you want to follow God's rules or regulations, I think would be a better thing to do. We love our guns. Guns kill. And that's, I guess, about all I have to say, and thank you for letting me speak.
I'd like you both to take on the question that she said we discussed just a little, but I want to hear you both. Do you think when they were nominees that that Justice Kavanaugh, Justice Gorsuch, and Justice Coney Barrett told the truth to the Senate about where they stood? And I'll start with you, Danielle. Do you think they told the truth to the Senate about where they stood?
I mean, when you listen to their language, these justices are very smart. They're very well prepared during their confirmation hearings. So there is nothing as explicit as we agreed to never overturn Roe versus Wade. I think the discussion in the confirmation hearings is really more about precedent. Do you respect precedent? So do you respect almost a half century of precedent in Roe, knowing that there's a very small list of cases that are as important as Roe that have been overturned by the Supreme Court? So I think that's more of the question. And I think that's where, at least in my view, listening to the confirmation hearings of especially Justice Kavanaugh, Justice Amy Coney Barrett, Justice Gorsuch, where it was very clear that they said, we recognize that Roe is the law and that Roe has been in place for almost half a century. And I think that is where I kind of take issue, is whether they are really respecting precedent. And if you don't respect precedent that way, again, not saying that precedent can never be overturned, but if it's simply a couple of lines, you disagree, you believe that the original decision was egregiously wrong, if that's the basis for overturning precedent, we are about to see an extreme activist court in this current Supreme Court configuration.
Josh.
Let me read you what Kavanaugh said in 2018. I'm sorry, let me read you what Susan Collins said about Kavanaugh in 2018. She said, someone who believes that the importance of precedent has been rooted in the Constitution would follow long-established precedent except in those rare circumstances where a decision is grievously wrong or deeply inconsistent with the law. Those are Kavanaugh's phrases. So Kavanaugh told Collins that there's an exception for precedent when a decision is grievously wrong. And I think it's no accident that Justice Alito uses that precise phrase in his opinion. I think you read from a few moments ago. So again, Kavanaugh, Gorsuch, and Barrett are not idiots. They knew what they were doing. They said what they had to get confirmed. I don't think they said anything that's inconsistent with what they're doing now. They said, well, respect precedent unless it's really wrong. And they found this one to be super wrong. They definitely didn't give any hints about Roe in particular. If Susan Collins thinks they did, she's wrong. No judge would do that, because to give a preview of a case would disqualify yourself, and they're not going to do that. But let me just pull a step back. If we go back to the Planned Parenthood Casey decision in 1992, Justice Blackmun wrote a concurrence, no relations, MUN. Justice Harry Blackmun wrote a concurrence, and he said something to the effect of, because of this contentious issue, my replacement will be scrutinized over his or her views on abortion. And what he basically said was every confirmation hearing from here on out will be about abortion. And that's been true. It was true of the John Roberts nomination, true of the Sam Alito nomination, true of the Gorsuch nomination, of the Kavanaugh nomination, of the Barrett nomination. Perhaps one of the few, not one of the few, but one of the consequences of this decision, if it holds, is that the confirmation hearings will be less about abortion because this decision is off the books. Now, in theory, it can be reversed again, and they could add 15 new justices and make a different court. But I think, if nothing else, this decision will make future confirmation hearings less about abortion, perhaps more about other things that are more insightful. Maybe not.
Let's go back to our phone lines and let's talk to Mike, who's calling from Huntington, Indiana. Mike, good morning.
Good morning. I'm a pro-life, but I think the guy should be punished just as much as a woman. They need to take and sterilize some of these guys along with the women. And in rape, they should just do away with the guy. That's just not right.
All right, well, Mike is advocating very harsh laws. Would any of what Mike said be constitutional? I'll start with you, Danielle.
Oh, why did you have to go to me first?
You can have that one.
No, I think that, one thing I think that to bring it back to something, a brilliant young scholar, Carlos Chapman, who's at Washington and Lee, has asked the question of, if we begin to go to a system where some states declare that a fetus is viable at conception, there may be other repercussions, including the question of, for example, does child support need to be paid right at the moment of conception? Will we begin to see custody issues arrive right at conception? So there could be other impacts. Again, I think the most important thing to emphasize about this argument is the question of government control over women's bodies, right? Because again, people can make decisions within their families, men and women together, women by themselves, depending on the situation, about how they want to handle their own health care. When I go to my doctor, I want to talk to my doctor privately about lots of things and may need to have certain procedures performed according to medical advice. What I would hope is that the government would not get in between those conversations between me and my doctor. Of course, pregnancy is different because there is a point in which a child could be delivered from a woman and be able to survive on their own. So there are two sets of interests, but a woman's interest to be able to control her own healthcare. I think we have seen countries that are much more conservative than us on issues of religion. So places throughout South America, even places like Ireland, that have recognized that women do have a right to be able to make these important healthcare decisions outside of the realm of the government, because one person's religion may not be another person's religion. So when we begin to talk about what God wants us to do, I am a very strong Christian, but when we begin to talk about what God wants us to do, that's theocracy, not democracy. And I think it's really important that we remember that we have women of all different backgrounds, many women who do not have any religious beliefs, and the government should not be able to dictate how women control their health based on individual legislators' beliefs about their own religion, and what their God may require of them may not be what a woman believes that God, if she believes in God, requires of her.
Josh.
I think I'll pass in response to the caller. I'm glad you called on Danielle.
Josh, I can't believe you're going to pass after making me answer.
Off everyone, off with their heads, right? I think, look, there are a lot of follow-up questions that will flow from this ruling. Maybe one issue just to sort of tee up that I want people's minds is, what is the state's power to regulate abortions beyond their border? So look, let's be candid. After this law, southern states, Texas where I live, will have very restrictive laws on abortion. California, New York, states in the Northeast and in the West will have no meaningful change. And I think these states will become basically beacons for women to travel across state lines to procure abortions. Now, what if, Texas makes it a crime to facilitate getting an abortion in another state? There are difficult questions over the reach, what's called extraterritoriality, right? How far can a law of states reach into another state and to effectively criminalize conduct in another state? That's really going to be the next front. And I think the courts will still be involved in abortion in the sort of peripheral or the secondary sense. It will no longer be about is there a right together, but to what extent can one state try to restrict their citizens from going to other states to procure abortions? I think that's sort of the next battlefront in these cases. So there'll be litigation, to be sure, but it won't be about whether there's this underlying right to abortion in the first place.
Just really quickly, just on my rudimentary understanding of the law, if a crime occurs across a state line, isn't that federal jurisdiction?
Yes, and in theory, I say in theory, Congress might be able to enact some legislation that protects people from traveling across state lines to procure an abortion, but the likelihood of that legislation doesn't look very good right now. And so there might be a vacuum in which the states could try to regulate. Imagine someone in Texas says, here's $100, I'm giving you $100, let's go buy a bus ticket to go to Colorado to get an abortion, right? That might be an act that takes place in Texas, which in theory Texas could criminalize.
Danielle?
I agree. I think that that is clearly what we will see after Dobbs is issued, is there will be some states who will not believe that they've gone far enough in trying to completely restrict a woman's right to an abortion in their own state, but they will try to criminalize. And again, I have to emphasize that these laws used to be mostly about punishing abortion providers. And I think one thing that we'll see is there will be moves to punish women who are seeking health care. And an additional punishment may be to punish other people who attempt to help women who are seeking health care across state lines.
Let's go back to our phone lines and talk to Lori, who's calling from Hamburg, Pennsylvania. Lori, good morning.
Yeah, hi. I believe that the justices are good judges separately, but as quickly as the Republicans moved in getting them in there, and the fact that I believe Kennedy retired as soon as Trump went into office, it just makes me a little bit suspicious. And it seems as though the right wing has like a process set up because they had these judges picked out already from the Federalist Society. And the other thing I worry about is that what if a child has a medical issue and the quality of that child's life is at stake? If she's going to lay in a bed for the rest of her life, and those parents cannot take care of her. I think they have tests now where they can determine that, and it's legal for them to get rid of the child for that reason. And I also think that the Constitution, when the people who set up the Constitution, they put in there that we had a right to religion, but religion was not to be the church was not to be a federal place, because the British, I believe, had a problem when they completely omitted religion. But I think this is really dangerous. It's going to create a lot of problems because a lot of the states that have strict abortion laws are based on their religion and not on the law. And I don't think that there's any equality laws for women. I think it's been ratified in 38 states, but it's not leaving us with very many options.
Final thoughts, Josh, on her comment or anything else?
I think if the majority opinion holds and there are 5 votes to rule Roe, the political aftermath will be ugly. It will be painful. People will have partisan clashes in the state legislatures. I don't like those clashes, but I would much rather those clashes than a rule by judiciary.
Final thoughts, Danielle.
I think it's incredibly important for the Supreme Court to protect our fundamental rights, like the right to privacy, which of course includes a right to abortion or limitations on states from regulating abortion. And if we begin to erode those rights, we will see that many of the rights that many Americans hold most dear will be in jeopardy. And so this will be, I agree with Josh, that this is going to be a crucible moment in American history. And we are going to see a tremendous amount of societal upheaval if the Supreme Court overturns Roe and Casey.
I would like to thank Danielle Holly Walker, Dean and Professor of Law at Howard University School of Law, and Josh Blackman, Professor of Law at South Texas College of Law, Houston, for being with us this morning and for this great conversation. Thank you so much.
Thank you.